Okay, so for this unit we're talking about financial and security regulations. Fun stuff. Now, keep in mind, a lot of interesting things happened in the 1930s, and that was because of the Great Depression. The stuff we're going to be looking at is designed to give potential investors factual information to make informed decisions. There are federal and state laws. It's substantially modified by the Sarbanes-Oxley Act of 2002. But before we get into all that, what is a security? This is what you get for your house. You put it at the middle of the hallway in your house, and you push a button, and it locks everything up. Or it's a gun. Maybe a dog. No. We're talking about stocks. We're talking about investments. In fact, the book even lays out a really good definition. I got part of it here in the outline. I'll read it to you. Security means any note, stock, treasury stock, bond, debenture, evidence of indebtedness, certificate of interest or participation in any profit-sharing agreement, collateral trust certificate, pre-organization certificate or subscription, transferable share, investment contract, voting trust certificate, certificate of deposit for security, fractional undivided interest in oil, gas, or other mineral rights, or in general any interest or instrument commonly known as a security, or any certificate of interest or participation in, temporary or interim certificate for receipt of, guarantee of, or warrant or right to subscribe to or purchase any of the foregoing. Yeah. All that. Basically, it exists when one person invests money and looks to others to manage the money for profit. So, how do you know you purchased a security? Well, there's a test that the courts have used in the past, and you got to ask yourself, is the investment in a common business activity? Okay. Second, is the investment based on reasonable expectation of profits, and will these profits be earned through the efforts of someone other than the investor? And again, when you think about this, look at what the first one is. Stock. So if you're going to buy stock in a company, if you're going to buy stock in Kroger, okay, the grocery store, does Kroger do a normal business activity? Sure they do. They're a grocery store. Do you expect profits from Kroger? Well, I would certainly hope so. They've been around long enough. And are they going to be earned through your efforts or the efforts of someone else? Well, the efforts of the people at Kroger. And certainly if you go to the grocery store there, hopefully you'll get some of that profit back. Now, the Securities and Exchange Commission, this was created in 1934. It consists of 5 commissioners. They're appointed by the president for 5-year terms. And they have quasi-legislative and quasi-judicial activities that they do. Now, they regulate stock exchanges, utility holding companies, investment trusts, investment advisors. Okay, so they're out there as an administrative agency trying to handle securities. Okay. Now, the Securities Act of 1933, this is going to apply to the initial sale of a security. Okay. So, when you think about this, you got to think about the disclosure law. This is what happens whenever you go public. Okay. So you're going to sell your stock and you're going to go public. There are sanctions. Okay. So if you intentionally don't obey the law, what could happen? Well, obviously there could be criminal punishments. There could be civil liability for injured parties, and even an injunction. The SEC could say, hey, you know what? You can't sell this security, and that's an equitable remedy. Parties regulated. Who is regulated when it comes under the Securities Act? Issuers, the party offering a security to the public. Underwriters, who participates in the original distribution, and they're the sellers for the insurers. Controlling persons, they're controlled by the issuer. They're probably a major stockholder. And then sellers, who causes purchase transaction to occur. So all these people are regulated. Now, there are several documents that are involved when it comes to the initial sale of a security. You got a regulation statement that's filed with the SEC. Disclosure of financial information. Pre-filing period. There's a waiting day period, and then a post-effective period. Now, when you have that, one of the documents you need is the prospectus, which is final financials, and this is provided to the investor There are detailed facts about issues. There's financial information. This all goes into the prospectus. Now, if you don't do what you're supposed to, there could be some liability. Criminal penalty for violations. Fraud, undue statements of material facts. You omit material facts, omit information relating to that could be misleading. There could be fraudulent transactions, attempts to defraud, attempts to obtain money or property, attempt to engage in transaction practice to defraud, deceive. But what are the defenses to this? Certainly you're going to say, hey, none of this was material. Since none of it was material, I disclosed everything that was necessary. A reasonable, prudent investor could make their decision. Could be a statute of limitations, meaning that it's been too long to go after the individual for not doing what they're supposed to. There's generally a 1-year statute of limitations. And due diligence, meaning that the investor had plenty of time to conduct their due diligence to make sure that the investment that they wanted to do was in fact accurate.